My name is Carlos Aro, and I'm pleased to welcome you to the 7th annual UCLA Latino, Latina Education Summit. The UCLA Chicano Studies Research Center has planned and implemented this summit series since 2006. This year, we're pleased to have the School of Law, UCLA Law School here with us as a co-sponsor, and the Mexican American Legal Defense and Education Fund, MALDEF, as a joint sponsor as well. In previous conferences, we worked closely with the Graduate School of Education and Information Studies, primarily through Professor Danny Solorzano. And you'll find research reports and policy briefs related to previous education summits at the back. There'll be a supply of those papers coming, and they'll be available for you to pick up. As I mentioned, Professor Solorzano was very much involved in the early series, the Education Summit, and the initial policy brief and research report dealt with the pipeline and how it was that we were losing our students, Latino students, at various points in the pipeline, and what were the reasons for that. Now, Professor Solorzano was not the only one that wrote policy briefs and research reports related to the Education Summit. Some of his graduate students also authored reports, and one of them is here. Lindsay Huber-Perez is in the audience. She is now an assistant professor at Cal State Long Beach. This year, the conference has a research report, Law, Social Policy, and the Latina Education Pipeline. That was prepared by Professor Robert Chow Romero. Robert is his birthday today. Robert is 40 years of age. And Robert is at the back. So we're celebrating not only the 7th anniversary of the Education Summit, but also the 40th birthday of Professor Romero. There are the policy briefs. If you don't get a paper copy today, the policy briefs and the research reports are all available online at the Chicano Studies Research Center website. And apart from the material that's available at the back, we will also have a book signing at the end of the conference, a book signing of several books. The publications by professors including Professor Laura Gomez, Michael Olivas, and William Perez. Those books will be available for you to purchase and to have the author's autograph signed in the next room, the Hacienda room. You just go out the entryway and it's to the right. There will be a display there of other publications and other materials that are have been produced by the Chicano Studies Research Center over time. So it's really very impressive to see what the Chicano Studies Research Center Press has published since the year 1970. Last year, the conference was jointly published with the UCLA Civil Rights Project, Proyecto Derechos Civiles, CRP, with Professor Patricia Gandara as the faculty coordinator. Patricia is here with us today, and she'll be a moderator of our first panel. That education summit focused on a significantly different approach for schools to take with regards to Latino and Latina students. And that was to use their language and their culture as assets, not as deficits, but as assets, to promote and to build success. The morning keynote speaker for that conference last year, that would have been the 6th Education Summit, was a fairly new dean to UCLA, Dean Rachel Moran. And it was at that summit that I first suggested to the dean that maybe the law school could join with the Chicano Studies Research Center in having this education summit. So it has become a reality, and I'm very pleased that Dean Moran was so positive about having this summit. This year, we are also partnering with the 16th Annual National Latino Law Student Association Conference, and it's being held here at the UCLA Law School. So there has been some confusion with regards to this conference and the law school conference, but this is the Education Summit. If you're a law student, you're welcome to be here. And in fact, there are going to be students that are attending that law student conference circulating into the various panels. So there'll be people coming, law students coming in, sitting in at various panels today. And we welcome them, and I'm very pleased that we were able to partner with the Law Student Association in offering this open to them. The third sponsor for the conference today is Montev. And Tom Sines, President and General Counsel of Montev. Now, Montev has been involved with this summit from the very beginning. And Tom has presented at two other education summits in the past. So we welcome Tom once again. But this time, Montev has several of its consuls, several of its attorneys presenting papers on litigation. And they will be in several of the panels here today. I want to especially thank the planning group that conceptualized the program, including law professors, Professor Laura Gomez and Stuart Beagle, along with Professor Robert Chow Romero from the Cesar Chavez Department of Chicano and Chicano Studies. They were wonderful colleagues to work with, and the program is a result of their good work. Now, the person that initiated the Latino Education Summit series is Professor Chon Noriega, the director of the Chicano Studies Research Center. In 2002, when Chon and I discussed my becoming the assistant director of the center, we agreed that the center should have a significant focus on education. And I recall having a meeting at his home also in 2005. This was at his home where we were discussing these ideas. We wanted to establish a programmatic focus on education. I recall having the 2004 symposium here in this room, Mendes versus Westminster School District, Paving the Path for School Desegregation, and Brown versus Board of Education. The center had implemented that conference here. And I was also planning in 2006 to have the conference on Sal Castro and the Chicano Youth Leadership Conference, the development of Chicano leadership since 1963. That was also held in this room. So we had a framework for the Education Summit. And we put that in place, and we implemented the first conference in 2006. Now, it was Director Noriega that approved the launching of this series, and I very much appreciate that he did that. That has kept me working. I retired in 2008, so I'm still involved. I am still involved, and I will continue to be involved to assure that the Education Summit series continues. Now, with regards to Professor Noriega, not long ago, we celebrated Chon's 10th year as director of the Research Center. His 15th year as editor of Aslan, a journal of Chicano Studies, the flagship journal in the field. And we also celebrated his 20th year on the faculty here at UCLA. The Research Center has certainly thrived under his leadership, and there have been significant growths. There has been significant growth and expansion to the center's library, the archive and collections that the Chicano Studies Research Center has now. There are over 110 special collections now under the Research Center. And of course, there's the CSRC Press and the Center's research and public service programs. I am pleased to report to all of you that he has been reappointed to another term as director of the Research Center, which is an organized research unit within the University of California. So we will have Professor Noriega for several more years. Professor Noriega.
Thank you, Carlos. I made the mistake of leaving my opening remarks up here, and Carlos just read them. So I am going to have to read Rachel's remarks, and needless to say, she will read Tom. So Tom, you have got about 10 or 15 minutes to start preparing something new. Welcome, everyone. I am so pleased to have you joining us here this morning and throughout the day for our 7th Latino Education Summit. As Carlos mentioned, and as you know, the focus this year is on law and policy. And one of the guiding ideas behind the summit has always been that of collaboration and of sharing. And I'm really thrilled that we are able to partner this year with the School of Law and with MALDEF, which has been involved throughout with this summit. And as Carlos mentioned, last year we collaborated with the Civil Rights Project, and throughout we've, needless to say, have necessarily turned very heavily to the Department of Education, which is in many respects an exemplary resource on this campus. I'm pleased to say that for the first time we have not only one Latino dean, but two, and they happen to be in the School of Law and the Department of Education. Marcelo Suarez Orozco starting as dean this year. And I think that's critical, but it's also indicative of really where the critical mass in terms of issues related to Latinos and issues of social justice, educational equity, and so on really are being fought over. And it's primarily in the legal arena and education. I want to kind of just amplify a little bit on background on the summit before inviting Rachel up for her opening remarks as well. This, when I came in as director, one of the first things I did was to go around and begin talking to the stakeholders for the center, both on and off campus. And I sat down with Antonia Hernandez at MALDEF at the time, and she really gave me a pretty significant insights into where the potentials and actualities were for collaboration between an academic research unit and an advocacy group working in the area of law and education. And it's from that, as well as through the context that Carlos had, that I was developing as a new director, that I began to realize that while I was talking to a number of people, there wasn't a forum in which they could talk to each other all at once, where there could be a sharing of the new scholarship that was being done in critical areas, the advocacy issues, the legislative issues, and the administrative issues that were being dealt with at the educational level. And we had this paradox, which was that 90% of the students in the LA Unified were not white. But you wouldn't say that the educational policy necessarily reflected that. And then when we looked at Montebello School District, where 90% of the students were Latino. And so Carlos mentioned, we had a dinner at my house, which really challenged my house, because it was a very small house in Echo Park. But somehow we managed to extend the table so that we could bring people together. I think Carlos was actually technically sitting in the hallway. But we had Victor Viramontes, who will be here today from MALDEF. We had a young guy who was the first time ever that there was the number 2 person in the LA Unified was Latino, Jose Huizar. He would later go on to be the president of the LA Unified and is now a city council member. And I'm sure Bill Maher supports him in all things except his position on medicinal marijuana. And we also had an assistant that Jose brought with him, Monica Garcia. who's now the head of LA Unified Board. We had Maggie Mejia and her assistant, who replaced her when she went to Sacramento City from the Montebello School District. And then we had the faculty from the Department of Education. Now, you realize at the time, unfortunately, there were no Latino faculty in the School of Law, but that's changed rather significantly in the last few years. We got together and I think really had that experience of the benefit of people coming from different sectors, from the advocacy side, from the school administration and policy side, and from the research end. And what came out of that in a very palpable sense was the need to have on a regular basis a forum where those people that were working in a key issue related to the pipeline, which I think we all agreed was really the key issue and the key area to address, that there could be great benefit in that, and that the synergy that would come out of that would be very helpful in the long run, and in the particular from our end as a research center, in terms of finding a platform for the research, finding an occasion to actually develop new research, and then the professional development, as Carlos mentioned. We necessarily involve faculty. What we do must be driven by the faculty interest, but within that, it's important to bring in the students at all levels, from undergraduate through postgraduate, and involve them in the research process. Give them authorship, co-authorship, so that we are part of the professional development. Many of the people that have been involved with the Education Summit in that regard have also been research fellows at the center, have been postdoctoral fellows. And we take that as an important part of not just talking the talk about education, but walking the walk, and really providing a way in which the center itself can be part of the pipeline, the professional pipeline. Carlos has gone over many of the topics we've done, but we felt it was important in the beginning to just look at the pipeline, which is leaking rather extensively throughout, and to draw attention to that. From that point on, we realized it was important to focus and to really hit specific issues throughout, whether it had to do with what can happen at the administrative level, to issues having to do with undocumented students, having to do with looking at education as an asset, a community as an asset, not a deficit, so that we could really thicken and deepen what we were able to do in addressing this. I'll conclude by once again thanking our collaborators, MALDEF and the School of Law, but also the Conference Planning Committee, Laura Gomez, Stuart Beagle, and Robert Chao Romero, and of course Carlos Otto, who has been central to this. He has a PhD in education from an okay university. Carlos had actually, I think, been at UCLA for about 50 years at this point. He tried retiring actually in 2006, and I wouldn't let him. I was able to hold on for 2 years until he cut his hand off, you know, and was able to retire. But I had the benefit of habit on my side, so he kept showing up every Monday because he'd been doing this commute for 42 years at the time. And so I said, hey, you know what, we'll actually cover a part of your salary for a day or two a week. Just keep coming in on Mondays and Wednesdays, you know, because on Wednesday he'd forgot that, you know, by Tuesday he forgot that he shouldn't be coming in. So he never came in on Fridays. Anyway, it's wonderful to have Carlos continuing and to make sure that we're able to really continue this summit. We'll be wanting to hear from you throughout the day as we deal with the issues related to law and education. What next? Where do we go next if we're really to focus our attention for the next year? This isn't something we just start planning a month up before. We need by the time we go into the end of this quarter to have identified the area, to have identified the faculty and the students, and begin framing out what is the research we need to do to kind of lay a foundation for an event like this. And finally, I'm going to thank an alum from the law school who's not able to be here, Henry Barbosa. This is unusual because this year we had the charge for lunch, which meant a lot of students were coming saying, we really want to be there throughout the event, especially lunch. And Henry Barbosa stepped up to the plate, and he is sponsoring a table. So you'll see a table of undergraduate, mostly undergraduate students, sponsored by Henry Barbosa. And I want to thank him for the support. He's been a big supporter of the center as well. So with that, I'd like to introduce Rachel Moran, and welcome. And I'm looking forward to taking part in this great conference that Carlos and the rest of the conference planning team have put together throughout the whole day. And you'll hear from me at the back end as well. Rachel.
Thank you, Chun. I want to welcome everyone to the Latina Latino Education Summit here at UCLA. The law school is truly delighted to be co-sponsoring this summit with the Chicano Studies Research Center and the Mexican American Legal Defense and Educational Fund. We're especially delighted that we're holding this summit in conjunction with the National Latino Law Students Association Conference. This is actually the third time that UCLA Law has hosted this event. We're the only school to have done it 3 times, and I do think it is a testament to the leadership of our law students. Now, this summit highlights the struggles as well as the victories of Latinos within the education and legal system. And as has already been noted, these are subjects of critical importance to our nation. The Latino population is the fastest growing in the United States, but it continues to lag behind in educational attainment. Between 1987 and 2007, the number of Latino students in public schools doubled from 11% to 21%, and the Census Bureau predicts that by 2021, 1 in 4 pupils will be Latino. And I gather from all my colleagues that the census is always wrong and that the number is actually bigger by that point. In 2005, unfortunately, only 58% of Latinos graduated from high school on time, as compared to 78% of whites, so that's a 20% gap. Today, Latinos' educational success depends on early intervention, high quality and motivated teachers, and systems of mentoring and support. According to a study of universal preschool programs in Oklahoma, Latinos benefited more than any other group from access to this early enrichment experience. But for the effects to endure, it's key that preschool lead to a strong program of elementary and then secondary education. Yet, Latinos are now the group most likely to attend schools that are hyper-segregated by race, ethnicity, and poverty. And they tend to be taught by teachers with less impressive credentials in schools with fewer resources than those that their white peers attend. And as a new book by Gary Orfield and Erica Frankenberg point out, this is not just a problem of our central cities. As we see patterns of suburbanization, as more Latinos move to the suburbs, these patterns of segregation replicate themselves. These problems in turn are compounded by the lack of support for students who face the special challenges of immigrating from another country, who speak a language other than English, who live in the shadows because of their undocumented status, or who suffer from a disability. As a result, Latinos' high school graduation rates continue to lag, even as the population grows by leaps and bounds and remains substantially behind those of whites and Asian Americans. And I think that the other part of this that we need to address, and is part of this pipeline studies, is that those Latinos who do successfully complete high school often do not get the guidance they need when deciding whether to go to college and where to apply. According to a 2010 study, Latino applicants often had academic credentials that would have permitted them to enroll in a college or university that was more competitive than the one they actually attended. And despite of that fact, in that they were somewhat overqualified for the colleges and universities they attended, they nonetheless lag behind in college completion rates. Now, these consequences impact Latino participation in graduate and professional schools. And you'll have the new pipeline study in your materials that are in the back, and I highly commend it to you, but there was actually an earlier one done in 2006. And that study, for every 100 Latino children who began school, 11 would graduate from college and 4 would pursue graduate or professional education. What's really alarming is that the numbers went down in this report, from 11 to 8 students getting their bachelor's and only 2 pursuing graduate or professional degrees. In the 2006 report for white children, for every 100 who started school, 26 were going to graduate from college and 10 would pursue graduate or professional education, over twice the numbers for Latino students. Now, I want to take a specific look at law schools, in part because I am the dean of a law school and because we're doing this in conjunction with the NALSA group. But today, the enrollment of students of Mexican origin has stagnated in American law schools. And I am very worried that access will become even more difficult because of rising tuition and limited availability to loans after new legislation that Congress passed. This is going to create a real squeeze for students who incur significant debt in college, come to law school, and are approaching the debt limits for federally funded direct loans. And so I think we are really going to have to work hard on Pell Grants, on other forms of grants, and support for scholarships at our law schools. Today, the American Bar Association has noted that the shortage of Latino lawyers remains acute. In California, for example, Latinos make under 5% of all California lawyers. So only less than 5% are Latino. Yet, the population of Latinos in the state is nearly 40%. So that is a huge gap. And I say this not because only Latinos can represent Latinos, but it shows just how seriously underrepresented we are in the legal profession. And by the way, they've done studies of various nations. The path to leadership in the United States has traditionally been through law. That is where we produce our governmental leaders. And in other countries, China, for example, engineering was the route. But I believe law school remains an important source of leadership. The Supreme Court made that same observation in Grutter versus Bollinger. So this gap is very significant. That is why it really means so much to me to be convening this summit in conjunction with the NALSA annual conference. By doing so, I think we not only have conversations across the disciplines, we're not only building community partnerships with MALDEF, but we are also enlisting the energy and vision of students. These students will have the tools to make a difference, and their presence here today demonstrates that they are motivated to make change happen. UCLA Law is committed to training leaders who go on to become citizen lawyers who provide the highest quality of legal service, but never forget their obligation to serve the greater good. We take the best and the brightest from all walks of life, and in fact, a recent study showed that there is only one top law school in America with meaningful socioeconomic diversity, and that is UCLA School of Law. So we want to continue to keep the doors open so that people can pursue their dreams. Now that I'm dean, I go out on the road and I meet our alumni, and it is one of the most inspiring parts of the job to see how transformative going to law school has been. We have traditionally admitted people from very modest backgrounds, but they have gone on to do great things in practice, public interest, government, and business. And I just wanted to give you a few examples. One has already been mentioned, Jose Huizar, UCLA Law alumnus. James Blancarte, class of 78, recently named Alumnus of the Year by the UCLA Latino Alumni Association, has represented celebrities like comedians George Lopez and Paul Rodriguez in his entertainment law practice. Antonia Hernandez, class of 74, was Tom Sines' predecessor as President and General Counsel of MALDEF and is now President and Chief Executive Officer of the California Community Foundation. The Honorable Kim McLean Wardlaw, class of 79, sits on the Ninth Circuit Court of Appeals, and Representative Linda Sanchez, class of 95, will be speaking to the NALSA participants tomorrow about her time in Congress. And by the way, she's one of the only sisters to ever serve in Congress simultaneously along with Loretta Sanchez. Stephen Islas, class of 72, who recently retired as the corporate vice president and general counsel of the Northrop Grumman Corporation, currently serves as trustee of the Amundsen Foundation. Diego Arp, class of 03, is Vice President at Wells Fargo Capital Finance and serves as Vice President of the UCLA Law Alumni Association. And I am only scratching the surface. This is power, this is voice, and this is what we have to preserve for the next generation of students. We fully expect this track record of excellence to continue. Our Latino students have been integral, not only in putting on the NALSA conference, but also in initiating and sustaining a wide variety of activities. Decades ago, Latino students at UCLA Law established the El Centro Legal legal clinics. This is a pro bono program that has grown over the decades. Now virtually every first-year student participates, and it attracts a number of people and serves a wide range of communities. In fact, the initiative won the Community Service Program of the Year from the UCLA campus in 2011. Student initiated, student sustained. Our Latino students also win prestigious scholarships and fellowships, are prominent in the intellectual life of our institution, and reach out to help peers in a spirit of collegiality. These students benefit from the guidance and support of committed faculty members, including Professor Laura Gomez, who helped to organize this conference along with Professor Stuart Beagle. We also appreciate other people in other departments who reach out, like Robert Chao Romero, to make sure that our students get everything they need at a great global campus. Taken together, our top students, leading faculty, and distinguished alumni helped to explain why UCLA Law was ranked the 7th best law school in the country for Latino students by Hispanic Business Magazine, and we've been in the top 10 ever since I started my teaching. So I'm very proud of that. So it's wonderful for our law school to be recognized in this way, but it's even more gratifying to know that as dean, I am part of a community of purpose with an impact that goes well beyond the boundaries of our campus. And I want to thank each of you for being a part of that community today.
Thank you, Rachel. And Carlos made me aware I was supposed to have introduced you.
Not necessary, let's move on.
Yes. But I will introduce Tom, and I will say Rachel's been a great colleague in the University of California, initially up at Bolt Hall, and we worked together, fought the good fight with the UC Committee on Latino Research, and she has also been director of the Institute for the Study of Social Change, which I think you can get a sense of listening to her. And Tom, as well, as somebody that I've known for quite some time at Waldorf, and then when he was the legal counsel to the mayor at the city of Los Angeles from 2004 to 2009, and then back again since he's been director or president and general counsel for MALDEF. I will just say that the Chicano Studies Research Center has been fortunate to collaborate with MALDEF and especially with Tom over the last 3 years in a number of areas, including healthcare access for Spanish speakers, hate speech and broadcast media, economic security. We even held a really wonderful event celebrating the Latino Theater Initiative publication that we did, and it just drew a very significant crowd, as you can imagine, being there at the heart of the city and at the MALDEF building. But also, and importantly, both in his capacity in the mayor's office and at MALDEF, just sharing information about UCLA. UCLA is the major public university here in Los Angeles. It is, in many respects, ground zero for all of the issues we're talking about, and should be the major point of destination for students in the Los Angeles area. So with that, I want to introduce Tom.
Now to this is not contracts class. You can move up to the front of the class. No one's going to call you out. You don't have to all sit in the back. But I was delighted and honored when Carlos Otto approached MALDEF about co-sponsoring this 7th Education Summit. Honored because I have a deep understanding of how important these summits have been throughout the years, having participated in some of them and certainly seen all of the critical education issues that have been the topic of research and the topic of discussion at summit after summit hosted and put forward by the Chicano Studies Research Center. I was equally delighted to learn that UCLA Law School, under our esteemed dean, would also be co-sponsoring the summit because I think it's a critical recognition of the very, very close connection between education and law. Now, that close connection is sometimes a good and warm connection, and sometimes a very unproductive connection, as I'm sure we have seen historically and we will discuss later today. This is a very important summit, and I think the research that has been put in front of us about the Latino pipeline is as important today as it ever has been, if not more important. That is because, as we now know, and many of us in this room have known for years, but finally the rest of the nation is coming to understand, the Latino pipeline is not just the Latino pipeline. It is a lifeline for this entire country. With the growth of the Latino student population, as Dean Moran has explained, really our nation's future depends upon our success in addressing the Latino pipeline issues that are laid out so powerfully and graphically in the report that is before us. And it is certainly true that there is a need in solving that issue, in making sure that that lifeline is a vital one for our nation's future, that we need to get together across disciplines to discuss what needs to be done. In agreeing to co-sponsor and then seeing the tremendous planning work that was done by Carlos Otto and Laura Gomez and others, this is a summit that will highlight some of the critical issues that we face as a nation in ensuring that that Latino lifeline to our future is a vital one that can come to serve the need to thrive and succeed in an increasingly changing and globalizing world. We have on our agenda today issues around affirmative action. You all know, and if you don't, you will certainly hear more about this in the succeeding panel, but next week, the United States Supreme Court on October 10th will hear argument in the case of Fisher versus University of Texas. And what you will see as the media gears up to cover that argument and talk about the issues and overanalyze what the meaning is of a question asked by a particular justice, and no doubt draw some mistaken conclusions as they speculate. But what you will see, and we are already seeing, is a focus on the African American community, when in fact the affirmative action issue, the issue of equal opportunity in admissions to higher education, has long been an issue that has focused in large part on the Latino community. I submit to you the following facts. The very first case in which the Supreme Court addressed affirmative action in higher education out of the University of California, University of California Regents versus Bakke, involved a challenge by a white student to a program that benefited more Latinos than any other group, that admitted more Latinos to the medical school at the University of California than any other group. And since then, we have seen many, many challenges that focus on the Latino community. As you will no doubt hear, part of the contentions by the Fisher plaintiff in the case that is before the Supreme Court next week is that Latinos, who are 38% of the population in Texas and an even higher proportion of those in the age cohort that are going on to universities, that Latinos are already represented in sufficient numbers, so that diversity in seeking a critical mass of Latinos already been achieved and no longer a constitutionally appropriate objective for the University of Texas. So from 1978 to today, you see that this issue of affirmative action in education really is about our community. Also on the agenda today, of course, the critically important issue of English language learners. That, perhaps more than any other issue, is the critical part of that lifeline to this nation's future. If we don't rapidly determine how to address the need to ensure that English learners have every opportunity, every equal opportunity, to excel and thrive and go on to success in higher education, then surely our country will be greatly diminished. So I was pleased to see that issue on the agenda as well. And finally, of course, the critical issue of the success of immigrant students and their access both to education from kindergarten through 12th grade and their access to higher education and beyond, their ability to continue in education, to law school, to graduate school, to education school, to many other endeavors, medical school, that will then give them the opportunity to contribute with their talents to this nation's ability to thrive. Now, in all of this, I'm grateful that we will be discussing cross-disciplinary considerations. I said at the beginning that there is a close connection between education and law, sometimes productive, sometimes counterproductive. And I can assert to you in this small room, knowing that it will not go beyond these walls, as a lawyer who represents an organization that was built out of the beginning of this civil rights era, and the beginning of this modern civil rights era can be pegged to the case of Brown versus Board of Education, a case about education rights, a case that went to the United States Supreme Court and had a monstrous effect, a tremendous effect on changing this nation to be truer to its constitutional values and principles. MALDEF was founded as a result of Brown versus Board of Education and the success of the NAACP Legal Defense Fund in pursuing that case over decades to the Supreme Court. And indeed, a critical part of MALDEF's own history over the last 44 years has been around lawsuits designed to achieve educational equity, whether it's fighting against segregation, a fight that we're still engaged in even today in 2012 in Arizona and Texas, whether it's about securing access for immigrant students. Plyler versus Doe is perhaps MALDEF's most famous and most celebrated appropriately case, most recently celebrated on its 30th anniversary by the administration announcing a program of deferred action for childhood arrivals. MALDEF has also been involved throughout the years in seeking to ensure a more equal education for English learners, most recently through the efforts of David Hinojosa, who you will hear from on the next panel, in Colorado, trying to ensure that Colorado invest substantially and necessarily in education for English learners. So MALDEF's history is all about lawsuits about education. But here's the confession that I know will not go beyond these walls. But if we leave education equity to the courts, we will fail. If the main accountability mechanism, as historically has been the case, to ensure equal educational opportunity in this country is lawsuits, we will never achieve that equity. And that is because lawsuits are notoriously inefficient at ensuring that throughout a system there is change that will yield equal educational opportunity. Now, if anybody says I said this outside the room, I'll deny it. But that is the truth about the law and education. Yes, we can set critically important precedents. Yes, we can get the ball rolling. But truly to ensure that we have equal educational opportunity throughout the nation, kindergarten through 12 and beyond, we have to derive mechanisms that do not depend on court intervention. That cannot be the solution. What we need to do is ensure that the rest of the country no longer has conversations about critical issues like Fisher, excluding the Latino community. Our educational pipeline is our nation's lifeline. And if people don't understand that, we must make them understand it. And in understanding that, make the further conclusion, the logical conclusion, that we must ensure that our education systems fit the students who are there. As Dean Moran explained, 1 in 5 public school students today are Latino. We will shortly be 1 in 4 of public school students throughout the entire nation. It is time that we ensure that the accountability mechanisms in place to ensure equal educational opportunity serve Latino students first and foremost. This is not unprecedented. We have an agrarian calendar in our education system, not because 100% of students were ever working on farms or living on farms. This was having our system be designed and accommodate a portion of the students in the system. We are now in a position as Latinos to ensure that our education system is designed to accommodate, is designed to serve the Latino students who are such a large component of our student population. Only if we are able to convince the nation of that and secure accountability mechanisms that don't rely solely upon lawsuits will we ensure that that lifeline is a vital one for the entire nation. Our mission today, and I'm grateful again and thank Sean and Carlos and Dean Moran for involving MALDEF. Our mission today is to find the way across disciplines to ensure that we can engage the entire nation in making sure that that lifeline is vital for all of us. Thank you.
Thank you, Tom. Well, you have your charge. I'm going to invite Patricia Gandara, who's the moderator of the first panel, to come up along with our speakers, Robert Charles Romero, David Hinojosa, and William Koski. And we'll begin our first panel. Those of you that have come in late and been standing in the back, we do have quite a number of seats up front. Please work your way up so that you can have a better view of the panel. And those of you heading out for coffee, just be sure to work your way up to the front once you come back in.
Buenos dias, good morning. I have the pleasure and the honor of moderating this extraordinary panel that you are about to hear. I'm going to tell you a little bit about the three panelists, but I can just tell you very personally that these are all individuals who we turn to in education, most of us in education, at the Civil Rights Project as well, turn to frequently for advice, for help. And these individuals are helping keep rights alive for Latino students. The title of our panel, I'm sorry, I didn't get that, is the emerging Latino trend of Latino resegregation in secondary and higher education. So you're going to hear about challenges to rights that have been won, but rights that have not necessarily been retained. And you are going to hear first from Robert Charles Romero, who's an associate professor in the UCLA Cesar Chavez Department of Chicano and Chicano Studies. He received his PhD from UCLA in Latin American history and his JD from the University of California, Berkeley. His current research examines the history of Mexican segregation in the United States and the important but much overlooked Mexican desegregation cases of Dawson v. Bernal in 1943, some time before the 1954 decision of Brown, Lopez versus Sicom, 1944, and Mendez versus Westminster in 1946. Romero's second line of research examines Asian immigration to Latin America and the large population of Asian Latinos in the United States. And his first book, The Chinese in Mexico, which I am looking forward to purchasing as soon as we can get over to that room, 1882 to 1940, was published by the University of Arizona in 2010, tells the forgotten history of the Chinese community in Mexico. We'll then hear from David Hinojosa, who is Southwest Regional Counsel for MALDEF in San Antonio. He is a leading litigator, advocate, and I can attest to a thinker in the area of education civil rights. His practice focuses exclusively on civil rights impact litigation on behalf of Latinos. He previously served at MALDEF as staff attorney and senior litigator, during which time he participated in litigation, advocacy, and public education efforts in Texas, New Mexico, Colorado, and 6 additional southern and western states. He served as the MALDEF attorney for Fisher versus the University of Texas case in 2008. He received his bachelor's degree from New Mexico State University and his JD from the University of Texas at Austin School of Law. And then finally, on this very illustrious panel, we have Bill Koski, who is the Eric and Nancy Wright Professor of Clinical Education and Professor of Law at the Stanford University School of Law. He received his PhD in education from Stanford. That's why you understand those issues so well. And his JD from the University of Michigan. An accomplished clinical teacher and litigator, he's the founder and director of Stanford's Youth and Education Law Project. He and the students in the Law Project have represented hundreds of disadvantaged children and their families in educational equity, disability rights, and school reform. YELP, the Youth and Education Law Project, currently represents more than 60 students from across California in the path-breaking Robles-Wong versus California lawsuit, which you will hear about, which seeks to reform California's dysfunctional and insufficient K-12 public school finance system. So I am going to invite Robert Chao Romero, to come forward. What we are going to try and do here is keep our initial comments actually fairly brief, allow an opportunity for a few minutes of exchange amongst the panelists, and then we want to preserve sufficient time for you to interact with the panel. So we're going to try and keep this at a clip. Thank you.
Well, good morning, everyone. It's a pleasure to be here with you, especially on my birthday. I was so inspired by the earlier talks by Dean Moran and everyone else that I really, well, it makes it a meaningful birthday to commemorate. So thank you very much. The goal of my talk today is to examine some of the historical reasons for the fissures and cracks in the Latino educational pipeline today. So I'm going to put on my historian hat and my lawyer hat and kind of put them together. In particular, my argument is that racially restrictive covenants of the early 20th century gave birth to segregated Mexican communities, as well as segregated Mexican schools. And that today, many of the predominantly Latino and low-performing schools in LA are actually modern-day expressions of the once formerly segregated Mexican communities and schools. So that's where I'm headed with all of this. Unknown to most people, in 1940, at least 200 segregated Mexican barrios or colonias existed throughout Central and Southern California. These colonias, again, overlap with many contemporary Latino communities. In fact, they overlap with many hyper-segregated Latino immigrant communities. Some of these historical colonias existed in Fullerton, Placencia, Santana, Pasadena, not too far from here, San Gabriel, Monrovia, where I live now, Whittier, Montebello, Pomona, and I could go on and on. Oftentimes, it is thought that the focus of the Latino community 100 years ago was just East LA. Well, as a matter of fact, it was much more diverse and scattered than that, as exemplified by these cities that I've mentioned. Many Mexican colonias developed as part of the Great Mexican Migration of 1910 to 1930, and the expansion of the citrus industry in California. Between 1900 and 1930, nearly 750,000 Mexicans immigrated to the United States in search of work and respite from the violence and disruption of the Mexican Revolution. Many of these immigrants were recruited to Southern California to work as pickers and packers for the burgeoning and highly lucrative citrus industry. To give you an idea as to the lucrativeness of the citrus industry, in the late 1930s, California produced 60% of all citrus consumed in the United States. And California citrus farmers earned $51 million in 1938. And of course, the backbone of this industry were Mexican laborers, pickers and packers. Despite their central role in the citrus industry, Mexican immigrants were deliberately segregated from the dominant Anglo community, and they were residentially segregated based upon three primary mechanisms. First, private real estate promotions. Second, company-sponsored housing. And third, confinement within poor neighborhoods through restrictive housing covenants. Now, I could speak about that for like an hour, but in light of time, I'm going to move forward and get to some of the present-day implications. As highlighted by the now famous Mendez versus Westminster case, again, which was the topic of focus several summits ago, in many instances, such segregated Mexican communities were tied to segregated Mexican schools. So the dominant Anglo community would push Mexican immigrants to live in enclaves, and they would establish segregated Mexican schools. For example, Pasadena had 2 segregated Mexican schools. The city that I live in, Monrovia, had 1 segregated school, and there's many other examples. So you had this pattern of colonias, which were in the San Gabriel Valley, created largely because of the citrus industry. Colonias and segregated schools and segregated pools, and in fact, Pasadena even had segregated hiking. Right? So if you're Mexican, you can only go hiking like on a certain day in Pasadena. It's crazy, right? We could speak a lot about that, but I want to sort of focus upon the connections, again, between the residential segregation and education. I'm going to turn now to this website here, and it's possible to get a glimpse into Mexican residential segregation patterns by looking at the confidential residential security maps for Los Angeles. And these maps were created by the Homeowners Loan Corporation in the late 1930s. And basically what they did was they enlisted the help of hundreds of brokers and realtors, probably maybe even thousands, and they went around to the major US cities and they said, okay, let's color code every major US city according to where all the minorities live, and we'll call those red zones, right? The place where all these threatening minorities live, we'll create these green zones for these like plush suburbs that are just racially monolithic, and we'll also create yellow and blue kind of in the middle. And so the University of North Carolina has created this amazing resource that was pointed out to me by my colleague David Garcia. I don't know if he's here, but a wonderful scholar in the School of Education. He showed me this, so I want to give him a shout out for that. And the red areas, as I'll show you, they represent, again, neighborhoods that were characterized by quote unquote detrimental influences in pronounced degree, undesirable population or infiltration of it, right? Low percentage of home ownership, very poor maintenance, and often vandalism prevailed. And I'm reading now from a description of the time. And you kind of get the picture there. And finally, it's worth saying that if you wanted to purchase a home in one of these red zones, you wouldn't get a loan. Right? So if you were a person of color, if you were Latino, well, you most likely had to live in one of these red zones. You couldn't live in one of the green zones, but you also couldn't get a loan to buy a house in the red zone. So you can imagine the conditions of many of these communities. Let me jump to the green zones. And again, I'm quoting from documentation of the day. Green areas are hotspots. In nearly all instances, they are the new, well-planned sections of the city, and almost synonymous with the areas where good mortgage lenders with available funds are willing to make their maximum loans. And so if you were white and you wanted to buy a house in the green zone, right, and you had lots of money, that's where you'd live. Okay? And as we'll see, those are places like San Marino, certain parts of Pasadena, Arcadia. And to bring this point home, I'm going to show you one of these maps. And again, this is an amazing resource if you want to take a look at it. The test bed for the redlining archives of California's exclusionary spaces. And let's see here. Let me see here. Demo. And you can click there for California cities. And you can again look at Oakland, Berkeley area, Fresno, LA, Sacramento, so on and so forth. And so I'm going to click on Los Angeles, and I think it's going to be very vivid. So realtors, again, hundreds or thousands of realtors, they carved up LA into these different color-coded sections. Again, green being the plush areas, red being the areas where minorities were concentrated, and blue and yellow being kind of in between. I'm going to zoom in. And I think you probably find this pretty fascinating, as I did yesterday. Let's start, let's see here. Let's go from west to east. So West Los Angeles, right where we are now, up here. It's really green, right? Palm Hills, Beverly Hills. West Los, but significant parts of West Los Angeles were red, actually, again. And every red zone I'm talking about here had a problem, most likely had a significant Latino population. You can think about it that way, as well as African American, as well as Italian, as well as Japanese, but definitely Latinos in most of these red areas will sort of scroll eastward. And again, and these are all, in case you're a grad student, all histories that you can do that haven't been told yet, for the most part. Okay, Boyle Heights, East Los Angeles, right? So we've familiar. And let's pan east. El Monte, right? Pasadena, northwest Pasadena, right, which has implications for today. There was a Mexican citrus community in what is now Hastings Ranch, right there. South Monrovia, where I live, El Monte. Baldwin Park is very red, right? And again, you can sort of see, it's fascinating, right? I mean, this is the 1,000 histories here. Let me, in the short time I have, I knew it was going to go real fast. Let me just give you an idea here, so you can read it for yourself, right? Boyle Heights. Let's click on Boyle Heights, where my family's from. My dad's a Rough Rider. Okay, you can view the description file. I'm going to do this so you can see. And for every, I'll do this real quick. For each one of these areas, they describe it, right? So, Boyle Heights, class and occupation, Jewish professional and businessmen, Mexican laborers, WPA workers, foreign families, 50%, nationalities, Russian, Polish, Armenian Jews, Negro 1%, Slav, Greeks, American Mexicans. And check that out, shifting or infiltration, subversive racial elements increasing, right? Subversive racial elements increasing, and it gets even more sad. It says, this is a melting pot area and is literally honeycombed with diverse and subversive racial elements. It is seriously doubted whether there is a single block in the area which does not contain detrimental racial elements. And I wish I could just show you all these other cities. I mean, you could do this if you pan on northwest Pasadena, Monrovia, all these places, you find the same pattern. And I'll do one more just to show you like a contrast. One of the green areas, I know my time is running really short, but I think it's worth it so you can see the way people thought about these things. And then I'll just close it up with a brief conclusion. Let me see. Pasadena, Huntington Library, very green. This is fascinating. The one this is Arcadia, Santa Anita Oaks. Okay, north of Foothill. So the class and occupation, business and professional men, executives and retired capitalists. Foreign families, 0%, Negro, 0%, and this is a fascinating thing about the covenants. Okay. Racial protection is in perpetuity. Racial protection. So they had these housing covenants that said, forever and a day, right? No people of color can live here, right? Now, let me bring it home, and I have a lot of stats to show this even more, but as you've probably drawn the connections in your mind already, a lot of the areas that were red back then are hyper segregated now, and are still the situs of low performing schools and underfunded schools and so forth, right? And the same schools that were really green back then, well, hey, I'll just give one example. San Marino High School, right? Very green back then. API scores, 937. Arcadia High, API scores, 885. Roosevelt, 608. Baldwin Park High, 712. And so, in this brief time, again, I hope that you can see the historical roots behind the fissures of the education pipeline. You can see it very clearly in the map, so thank you very much.
My name is David Hinojosa. I'm the Southwest Regional Counsel from MALDEF, and I'm very happy to be here. Thank you, Patricia Gandara, for the great welcome. this morning, as well as the Chicano Studies Research Center and the law school. I'm here to talk to you about the Fisher v. Texas case. I do want to mention real quick, though, that I started school out in San Bernardino Valley College. I'm from Texas. My parents retired there from the military, but I started school out there when I was stationed as an air traffic controller at Norton Air Force Base in San Bernardino, and so I'm very happy. And I also am one of the many Los Angeles Lakers fans in San Antonio. So I have no apologies to my Texas friends who might be here. And I'm also glad to come full circle because I was at the National Latina Law Student Conference a few years ago. Well, not a few years ago, back in 1998 or so, 1998, 1999. So I'm really glad to see all the students who are here and everybody else. So with that, Fisher v. Texas was filed by Abigail Fisher and another white student in Texas who were not admitted to the University of Texas in the year 2008. They applied. Just to give you a little background, in Texas we have the Top 10% Plan. The Top 10% Plan was born out of, in part, the Hopwood case. The Hopwood case was the affirmative action case filed by white students who did not get into UT law in the early 1990s. In 1996, the Fifth Circuit held that, essentially held that diversity is not a compelling interest and that the facts weren't there for an affirmative action plan to overcome some type of a then existing discrimination. And so the issue was kind of closed there, and there were some upward trends of Latinos and African Americans attending Texas's flagship universities there in the mid-1990s, and then all of a sudden it halted because of the Hopwood decision. And so Texas went to work and they said, well, what can we do to help increase diversity at our flagship campuses in particular? And so they developed the Top 10% Plan, and I will say that we are defenders of the Top 10% Plan. You have issues here in California with your Top 4% Plan, and we certainly share those with you. But in Texas, we know it's not a perfect plan. That's why we've argued for a blended, don't end it approach. But you know, the gains that have been made, and as a result, in part because of a lot of the past discrimination in Texas with communities. You know, we have Mexican schools out there in Texas as well. You'll hear about some of the unequal opportunities that certain districts people have in their elementary and secondary schools. And so, you know, the Top 10% kind of addresses that because it opens doors to students who never thought they had an opportunity. I went to Edgewood High School in San Antonio, one of the poorest school districts in the state of Texas, from the infamous San Antonio ISD versus Rodriguez case, if any of you are familiar. I went to that Edgewood High School that is now closed. And I know what it means to have a lack of opportunities. I didn't know it until I graduated and found out just how good others had it. But, you know, but it didn't make me any less. You know, I barely broke 4 numbers on the SAT score. And this is before you all got the inflated SAT scores, by the way. You know, I barely broke 4 numbers, yet I was the highest performing student out of my graduating class of about, we started out as about 800, 900 freshmen, and I think we graduated a little less than 200. But, you know, here was the best performing student, at least on a standardized test, one time, you know, taking that standardized test for what it's worth. And that's what we were producing. So, you know, the Top 10% was saying, hey, look, it doesn't matter if you go to an Edgewood. It doesn't matter if you go across town to the Alamo Heights, which is the more affluent school. If you rank in the top 10%, you must be a hard worker. You still have to have a basic curriculum that you have to have completed, and we're going to open our doors to you. So the Top 10% Plan did open the doors. But of course, it's not going to be the be-all, the end-all approach. It brought us back to the pre-Hopwood levels by the year 2002, 2003, depending on what numbers you're looking at. But that didn't mean anything, because just because it brings you to the pre-Hopwood levels doesn't mean that the pre-Hopwood levels were any good back then. And it also doesn't take into account the increase, the 97% of the total population increase in Texas public schools was a result of Latino and African American students. And I can tell you Latinos were a much larger part than the African American students. But that's 97% of the growth, and yet you're saying, well, we're going to return you to the pre-Hopwood levels, that's good enough for you. So UT surveyed students to see what their feelings were on campuses, and that was after the Grutter decision in 2003, by the way, held, of course, that universities do have a compelling interest in diversity, and they can pursue it so long as they don't just do quotas, they don't have hard targets, and they're not giving plus points just because of someone's the color of their skin. So following the Grutter decision in 2003, UT said, well, let's survey the students. Let's do a classroom survey also to see how many minorities or African American and Latino students. Because what they did, one of the first things they did was, well, we're going to look at the demographics of Texas. We're going to see, and we're also going to look at labor issues, pathways to leadership. And what they saw was a really big mismatch between the number of African American and Latino students attending the schools and the demographics in the state as compared to many of these different professions, and so they looked also, after they did that, they did a survey of students. They also did a classroom study to see how Latinos or African American students might be lacking in certain classrooms. And they found that 90% of the classrooms that were 5 to 24 students had 0 or 1 African American students. 43% had 0 or 1 Latino students. They examined their outreach efforts because they had been doing all this outreach to Latino communities, among others, to try and recruit students. And they examined their role as a flagship university to see, are they producing a diverse group of leaders that will lead not only Texas well, but the nation well in our growing international economy. And so by that time, they decided to, oh Mike, can I get you? So by that time, they decided, UT had decided to add race as a factor of one of many other factors in its holistic review. And this is what UT's plan looks like. 75% now, because the top 10% was doing pretty good, and UT fought us. I'll get into that in a little bit. And so they capped it at 75%. 25% is the non-top 10%, although it's now what we call the top 8%. But under one part, you have the academic index, and that might look at, among others, high school curriculum, GPA, SAT, ACT. And then on the other side, you got the personal achievement index, and that accounts for 50% as well. And you have 2 essays that students can write, and then you have these other factors. I'm not really great at PowerPoints, by the way. Everything is supposed to kind of like flow up. But I'm good in there. And so then you have all these other factors, right? Leadership, special circumstance, extracurricular activities, honors, because they don't want to just look at test scores, right? They want to look at the whole person so they can get a more diverse group, and in diversity among many other things, not just one. So then they got these special circumstances, and we got socioeconomic status, single parent, language, family, responsibility, SES of school, school average. Then they added race. As the Fifth Circuit found, and the lower court found, race was a factor of a factor of a factor of a factor. It was not the factor. There was no plus or minus. But nevertheless, Abigail Fisher, whose suit was fronted by a number of very conservative right-wing organizations, filed the suit. She lost in the lower court. She lost in the Fifth Circuit. Imagine that. A white applicant loses an affirmative action case in the Fifth Circuit. But I will tell you that, the Fifth Circuit's opinion, if you look at it, and it's not just, for scholars who can digest this type of thing much better than, your average lawyers and litigators perhaps, and, certainly law students. But if you look at it, you wonder, why did they go so far? It's almost like they were inviting someone to overturn Grutter because they extended it so far. And they didn't need to do that. They didn't need to provide such substantial deference to the University of Texas. They could have taken an easier, much more conservative approach and still reached its final conclusion. But they didn't end up doing that, and I'll get into that a little bit more in the end. But the plaintiff's argument was that UT didn't necessarily have a compelling interest. At first, when they filed their case, they didn't say that they didn't have a compelling interest in diversity. That was missing from their complaint. They later ended up amending it after a hearing, and the judge basically said, well, you're conceding that they have a compelling interest. And they said, well, wait a second, maybe we're not really saying that, we just left it out. And we, MALDEF, had attempted to intervene into the case because, one, we didn't trust UT to defend the plan as vigorously as it might, and perhaps there was some evidentiary issues that could have been added to the record that we would have brought, and also the NAACP LDF, who had also attempted to intervene. We attempted to intervene on behalf of Longhorn LULAC, a UT student organization, as well as individual students who were either presently attending UT or were hoping to attend UT but were outside of the top 10%. So they argued that they didn't necessarily have a compelling interest, and even if they had a compelling interest, it wasn't supported by what they call the strong basis in evidence. And I'm not going to bore you with this legal doctrine, but essentially they basically said, well, there's no empirical evidence that they could have used, to show that it was necessary to further their compelling interest. It's something that they imported from affirmative action employment cases, something that was totally missing from Grutter, but nevertheless they're going to keep trying because conservative courts can be just as activist as liberal courts. So they said that there's no, and they also said that you can't necessarily have critical mass. So UT had done not a student body, they didn't look at their student body as a whole. What they did was look at classroom demographics, and they were trying to see, well, are we having this cross-racial understanding that helps break down racial stereotypes, going on in the classroom? Are we having this robust exchange of ideas? These ideas that the U.S. Supreme Court itself had already found in Grutter. And they said, well, that doesn't mean just campus-wide. It has to mean something in the classroom, because that's where you have the robust exchange of ideas. That's where you get to know other students more intimately. And so they also argued that there was the plan, because whenever you use race, which admittedly UT does use race, you have to have a compelling governmental interest, which of course in this case would be diversity, and then it also has to be narrowly tailored, so the means that you are going to employ. And what they basically said was, well, these means aren't necessary, and they're not narrowly tailored because UT already has a race-neutral alternative, the top 10%. That's already given them whatever diversity they need, because even though there's not supposed to be a goal, they kind of want to say, well, 14% in Hopwood was good enough. Now all of a sudden they're at 21% of Latinos alone, and that should be good enough. They also said that UT's use of race for Latinos as opposed to Asian Americans was over-inclusive because the Latino numbers were right at par with Asian Americans. And in the end, what they really want to do is get rid of Grutter, either by getting it expressly overruled, which they have actually asked for in their petition, or to get it underruled, and that means to render it meaningless. And so we've argued, we filed an amicus brief in this case because we still participated as an amici, filed a brief in support of the motion for summary judgment on behalf of UT. We also filed a brief in the Fifth Circuit. We also filed a brief before the U.S. Supreme Court on behalf of 22 national Latino groups, including NCLR, NALEO Educational Fund, LULAC, many others. And I'm starting to speak really fast because Patricia has told me to stop. So, we've argued in our brief about the important roles of Latinos, and when it comes to civic participation and how civic participation is affected by the level of education, leadership potential, military leadership. We have we constitute 12% of the enlisted forces, but only 5.5% of the officer corps. In the private sector, economic importance, and also the continuing institutional barriers. I think Texas just proved once again how far behind they are than others in voting both in the voter ID decision that was issued recently by a 3-judge panel in DC, as well as the redistricting decision issued where the court found that the state of Texas had once again participated in intentional discrimination against Latinos. Unfortunately, but not surprising. But real quickly, the problems that we have moving forward are, with the case, is that UT, this is, the growth pattern at UT, the enrollment at UT. But then when you look at UT, because what they basically said, what the plaintiffs have said, well, and my colleague at the LDF calls it the Goldilocks problem. You either have too much or too little, what is going on here? And but one of the problems at UT actually is that when they are supposed to use race under the diversity admissions plan, the non-top 8%, you got 58% of those students, when you can use race, they're not necessarily using it, or maybe they're using it for white students. But when you look at the race neutral top 8%, you have that. And then one of the other issues is, oh, I did some technology thing here. I did not know that I did. So when UT is allowed to use race, and you look at all the total freshman admits, 1 out of 3 whites is admitted under the non-top 10%. 1 out of 5 for Asian American and African American. 1 out of 8 Latinos is admitted to the non-top 10%. And of course, numbers mean something because they're only talking about 25%, but numbers also mean something because 1 out of 3 whites is getting in, even though you're talking about only 25%. So let me just go one more thing that I want to point out here is that you saw the factors, right? Under the non-top 10%, when you can use income. When you look at the parent income of the top 8%, less than $60,000, that's 35% of the kids, compared to the non-top 8%, where it's 14% of those kids. But then when you look at really high incomes, there's a much larger percentage of the non-top 10%. Parent education as well. 16% of the top 8 have a high school diploma or less, only 4% under the non-top 8%, and then the bachelor's degree as well. It's a real telling story, and it's quite unfortunate. Now, that said, we of course want the decision in the 5th Circuit upheld. This, as Tom had referenced earlier, is a battle for beyond the courts. This is not going to be rectified necessarily in the courts, but it does need, to be at the forefront of the issue, or else we won't get anywhere. So I thank you very much, appreciate it, and thank you, Professor Gonzalez.
Bill Koski, and it's a real privilege to be here today to be speaking on the panel with David and Robert, and Patricia leading us as a moderator, and I want to thank the sponsors of this event. It's a terrific event, and I'm proud to be here with you today. I'm also quite pleased that it's being jointly sponsored by the law school. It's one of those struggles that I have back at Stanford, is trying to bring together law and educational policy in a meaningful way. As Dean Moran had just finished telling us, these things do go together. It's quite important to see law students working on the front lines of civil rights work, which I believe is educational rights work at this point. So I really do appreciate the effort behind this. Before I get going, I have 2 disclaimers. First of all, this is not an academic presentation. It doesn't pretend to be unbiased. This is a flat-out advocacy presentation because I have the great privilege of representing 62 children from across the state of California, from little Del Norte County, way up in the north, and it is Del Norte, that's how they pronounce it, Del Norte County, north, to Alpine, way down in the south, over Folsom Cordova in the Central Valley, bedroom suburb like Alameda, San Francisco Unified, Riverside Unified. We have kids from all over the state of California in the Robeswang against California school finance litigation. And I have the privilege of representing the kids in coalition with a number of other organizations that I'll talk about in just a moment here. And what we're trying to do with the Robeswang case is have the state Supreme Court, because ultimately that's where it's going to be, overturn California's well-known dysfunctional and insufficient school finance system. This is a broad school finance reform project with the hope of benefiting all California kids. But why I think it's particularly relevant to this group, and why I think it's particularly relevant for Latino kids, for English learner children, is that what we are trying to accomplish here is going to most impact children who are Latino, children, immigrant children, and Latino children for two reasons. One, they're going to be the majority of the public school population very shortly, if we haven't already surpassed that mark. And second of all, when it comes to the areas where equity is most needed through the kinds of remedies that we're looking for, targeting towards English learners and economically disadvantaged kids, this will disproportionately, I hope, benefit those who are being disproportionately underserved at this point. So what I'd like to do is make three broad points here. I'm going to very briefly talk about systemic educational inequality in California. I suspect that this is familiar terrain to many of you, but I also want to work a little bit on defining the problem in the state and why it is that courts need to be part of the solution, and that is because of the failure of politics and legislative inaction. Second of all, I'd like to talk a little bit about the doctrinal history and where we are today in terms of educational rights litigation, particularly litigation surrounding trying to improve the resources for economically disadvantaged kids. And then finally finish up by talking a little bit about what's next. What if we get the opportunity to win, or maybe move the needle just a little bit in the legislature through this kind of influence, what kind of remedies would actually benefit the kids that we're most worried about? So educational failure in California, very briefly. These are broad-based numbers. I want to point out that California students as a whole are not doing well compared to our nation. If you look at fourth grade reading, we read at the 38th percentile of the nation, and we're at the 20th percentile of Massachusetts. These comparisons get much worse internationally, and that's why in Silicon Valley, where I work, we have to import kids from North Dakota, Minnesota, and Uttar Pradesh. We need to stop that as a state. It's crazy, right? We need to home grow our talent. Same kind of thing works out when you look at it in math scores. But what I really want to focus on again for this group again is it's not only the overall poor performance of California kids in academic achievement, it's the achievement and attainment gap that we see between Latino and African American kids on the one hand and white and Asian American children on the other hand. No, obviously the Asian American category is not a monolith. We see a lot of different performance depending on what part of the globe you're from and all. But these are pretty big gaps here. I'm not going to go through and read them, but you can see whether it's in math, California standards tests, English language arts, California standards test, or the completion of A through G requirements. I suspect many of you are from California, and certainly those of you who went to California public universities know you need to complete the A through G course sequence in order to even be eligible for Cal State or the UC system. Vast disparities in terms of that attainment. So how do we get here? This is a pretty big can of worms, because right now as we're sitting watching an election unfold here, even within the Democratic Party, there's a big argument about why our children in our schools are failing. You could talk about teacher collective bargaining rights being the problem. You can talk about, all this and that. And I think that's a distraction. The real problem, and this is the case that I'm making, is under-resourcing our economically disadvantaged kids, our English learner kids, and kids of color in our schools. That's the real problem here, and overall underfunding here. I won't get into the politics of it. I'm sure somebody out there will argue with me later on whether or not we need to fix some of the governance structures before getting to finance. I think we've got to start with resources before we even talk about that other stuff. So I'll let you kind of read through those for a moment here. If you look at overall per pupil funding, just sheer dollars, these numbers are a little dated, in fact, and it's much worse now that we've hit this economic collapse. California spends much less on average than the, and ranks 47th on a cost-adjusted basis in terms of per pupil funding. If you look at a different kind of index that includes economic and poverty type factors, we rank 42nd. So that's pretty bad. But if you translate that into real numbers and look at the states that we would most compare with, such as New York and Texas and the like, we rank, in each of the largest 10 states, we rank the last among those. And significantly, $6,000 per student, less than New York. Imagine if you're a third grade teacher, what you could do with 6,000 times the 20 or 30 kids that you have in your class. You can buy a whole nother teacher with that. And that's what this is. This is the staffing ratios in California across a whole different range of things. Students per teacher, counselors per teacher, librarians per teacher. Focus on that counselor thing for a minute. If you're talking about pipeline issues, looking back at how you ended up where you are, maybe it was that counselor that helped you figure out how to navigate the college process. Maybe it wasn't. If you're from California, it probably wasn't, because you didn't have a counselor there to do it. But elsewhere, I think they do have those people working in the schools helping kids get to college. And then focusing specifically then on the Latino population, I'm stealing blatantly from John Rogers and the folks at the UCLA IDEA group here. When they did a report on Latino educational opportunity, they showed that no matter on the measures that they surveyed, whether it was overcrowding, whether it was access to qualified teachers, or whether it was college preparatory courses, over and over again, they found that Latino kids had less access. So not only is there an overall resource problem in California, it's concentrated on the kids that, you would expect, frankly, and then we need to change that equation. So what's the problem? I could go on and on about this, but I'm just going to say in one sentence or so that the problem here is a massive disconnect between the way we fund our schools and what we expect of our schools. We have in place a set of 21st century academic content standards. We can quibble with how good they are, how broad they are, whether or not they're deep enough, all that sort of stuff, but the truth is they're tough, and we've built an accountability system around them, we've built a teacher training system around them, we do everything around them, including holding kids and their teachers accountable. But what we don't do, we don't provide the money necessary to support those standards. There's a complete disconnect. Our finance system is based on outdated formulas from literally the 1970s, our so-called revenues limits formulas, bad budget deals, initiatives that were well-intentioned but have kind of gone awry, i.e. Prop 98, and categorical funding streams that are the product of pure politics in Sacramento, not actually what it takes to educate kids. Everybody knows about this problem, whether it's the Governor's Committee on Educational Excellence under Arnold Schwarzenegger, whether it's the Getting Down to Facts research project that was a collection of 29 or so studies, including folks from UCLA who participated in that. We've known about that. I was sitting in the Claremont Hotel in Berkeley 12 years ago, and I bet one or more of you were in that room at that time, where the decision was, the legislature ain't gonna fix this. We gotta sue. We didn't sue, we lost another generation of kids. So the thinking has to be, there needs to be an external shock to the system. Litigation is not going to solve all the problems, but the one thing litigation can do is it can change the conversation, hopefully, at a minimum. It can hopefully change the politics, and that's the aim of the Robust One litigation. By the way, so can a ballot initiative, so can grassroots organization, these kinds of things. All of that's necessary too, but litigation is what we looked at. Fortunately, the California Constitution does say something about education, as do 48 of the other state constitutions. They have education articles. In California, the legislature is supposed to provide for a system of common schools. Forget the 6 months out of every year piece of that thing up there. Let's read that through our modern lens a little bit. But there is a legislative obligation to have a system of common schools, whatever that means. We don't know necessarily what that means. I'll tell you, in at least 22 other states, that means a thorough and efficient system of common schools means there's a qualitative right to an education, a right to not only access to something called a school, there has to be some quality to that education. Certainly our friends in Texas know a lot about this, including the education equity stuff they have. So there's some text to work with here in California. And in fact, this text has been interpreted over the years. In two cases, the Ward and the Piper cases, there was access to education. In the Hartzell case, we started to build out the fact that education means more than access. It also means access to free schools in terms of extracurricular activities. We then had, as part of the early school finance litigation era, the seminal case, Serrano against Priest, which was basically an interdistrict equity case based on equal protection ideas, not necessarily Article 9 educational rights ideas. But even in the case of Serrano against Priest and Butt v. California, the idea that education is integral to the health and the economy of our state, and that the state has an obligation to provide for that fundamental interest in California, was articulated. So for us, it's a short step to then saying there's a right to an education, The state's clearly not providing it, and it's because of the under-resources that we have here in a dysfunctional system. Now, I just want to say there's been a heck of a lot of other resource litigation going on over the past 10 years here, and our friends over at the ACLU of Southern California Public Counsel have brought a number of these cases focused on equalization in advanced placement cases, the Williams litigation, which was around basic educational necessities, equitable distribution of teacher layoffs right here in LA Unified, the Reed case, access to free instructional materials, which Governor Brown just signed the bill saying, yeah, you do get to go to school for free, actually. We meant it. And there were a couple of other cases here, including the most recently filed one, the Students Matter case, which rather than challenging the resources, basically says that it's the conspiracy of teacher employment laws that protect teachers that are causing student failure in California. So that's where Robust Wong comes in here. We have, we believe, text to work with. We have, we believe, a few cases that if you add them up, any good law student can add them up, it says that there's access to a quality of education, some qualitative right to an education. Good news is, the legislature has defined that through the content standards. It doesn't take a heroic court to say what an education ought to look like because the legislature has done that. And so we, through this litigation, have sued on this idea of a qualitative right to an education. I gotta stop. A qualitative right to an education that has been denied to kids, and that it is the cause of that problem is the school finance system. The content of that qualitative right, as I said, is very much defined by the legislature, so it doesn't take an act of judicial heroism to make up what education means in California. I will say we've been getting our butts kicked so far. We were dismissed by the trial court, which is fine. Judge Brick in Alameda County is an incredibly smart judge, and he does, I think, read the case law differently from the way that we do. We have appealed the case, and we've joined together with our friends from the Coalition of Quality Education and Public Advocates who represent a few other grassroots. We represent children. There are 9 school districts in our coalition. There's the California School Boards Association, Association of California School Administrators, and the state teachers union, the California Teachers Association. That's some unholy bed partners right there, right? I mean, I usually sue school districts. So I'm in with these school board guys, and then you got unions and management. It's a mess. But if we win, I'll just leave it at this. What we're asking for the court to do is a modest thing. We're asking for the court to strike down the current finance system and tell the legislature, go back and fix it based on a couple of principles. One, that there needs to be some coherence, some connection between what you demand of schools, what you define as the right to an education on one hand, and the finance system or the resource system that provides it. And importantly, this resource system has to give all kids an opportunity to be successful on that educational program. And that means we need to focus on student need. And here's where the new work is being done legislatively in California, and hopefully with the goosing of our litigation, it'll get better. We're working on looking at things like weighted student formulas that take into account student background needs and the like. We're looking at ways to particularly look at English learners and economically disadvantaged kids in the process. We are on the slow boat right now. Appeals will be heard sometime in the beginning of the new year, but hopefully we'll get a win and move this thing along at some point. In the meantime, we can talk about ballot initiatives and other stuff like that during the Q&A, so thanks.
So I want the panelists to know how hard it is for me to be hard-nosed about this, because I want to listen to you guys too. But we do have short time, and I do want to make sure, I think we're going to skip the interaction of the panel because we've really only got maybe 10 to 15 minutes, and I do want to give an opportunity for folks in the audience to participate as well. So where are the burning questions in the audience? Or the burning, and I will just say right now, if it's a comment and not a question, really brief, okay? Really brief. Yeah, red shirt.
Hello, my name is Luis Cortez. Thank you so much for coming to the panel. My question really kind of focuses on what Mr. Romero said and what Dr. Koski has said. In California, one of the things that, so I used to teach in San Mateo County, so I'm really close by Stanford. And one of the things that we saw is speaking about the per pupil financing and the way in which schools get money. Part of that is through property taxes around the area. And so what started happening a lot, especially where I was teaching, was that they started redistricting, not according to race, but according to how much money was around those neighborhoods. And there were circumstances where even within the same household, within 3 different siblings, kids would go to 3 different high schools, even amongst the siblings, because the lines were drawn based on the property taxes going down, then the kids would have to go. What kind of work is being done around fixing or challenging the redistricting lines based on socioeconomic status? And that's kind of useful for whoever.
So let me try to tackle that. I'll say 2 things. First of all, in the way that the school district lines were drawn, there's clear racial gerrymandering. I think on the San Francisco Peninsula is a perfect example. If you look at how Palo Alto Unified and Menlo Park Elementary School District, and then the East Palo Alto District, which was called Ravenswood District, and is almost 100% kids of color in that district. You know, it's this snaky little thing that basically outlines that tone. So I don't know the history, but it was probably, at a minimum, socioeconomic, probably racially gerrymandered at that point. In the past, those were challenged through desegregation cases. Now that's, we still do have in place a desegregation decree in the Palo Alto area called the Tinsley Transfer Program. That exists, but that only lets a few kids jump the border, so to speak. So there's not a lot, truthfully, being said to tackle those political boundaries that we call school districts, unfortunately. There is sort of a flip side that's a little bit of good news here. If you look at it from a national perspective, California at least funds its schools in a way that's more equitable than a lot of other states, believe it or not. We get better grades than a lot of other states, mainly because of the Serrano litigation and the way that schools are funded from Sacramento, from a very centralized place. Now, wealthy communities have end-run that through parcel taxes, through so-called local education foundations and the like that raise money privately for their local public schools. But by and large, you know, there is, in terms of operating revenue, some degree of equity. But when you look at the schools, there's a difference, and it's because of these end runs. I don't know what to do about that.
Was there okay. Yes.
I was hoping David Hinojosa could talk about
Just
the.
stand up and identify yourself.
My name is Pedro Hernandez. I'm from Hastings. Had a question about whether, if you could list out the possible outcomes of the Fisher case and whether or not what kind of precedent maybe parents involved can have, because that was a K-12 case, but they talked about the factor in de jure segregation in that case, and Texas being a de jure segregated state at a time, I don't know if that will hold some sort of. Okay.
Great. Question is, you know, what kind of outcomes could we anticipate from the Fisher case?
Ideally, you know, they just affirm the decision from below, and we're done. You know, that's pretty substantial deference that the Fifth Circuit gave to the University of Texas, both on the compelling interest side and the narrow tailoring side. Like I said earlier, I don't think that it was necessary, but they did do that, so that's one outcome. The other outcome is, and I don't think that it's likely, I really do not think that Justice Kennedy, at the very least, because that's, you know, what matters. You know, if Justice Kagan has recused herself, so it's down to a 4-4. That's all we need is a 4-4. So regardless, even if Justice Kagan was there, we would need Kennedy. Justice Kagan not there, and unless, you know, Roberts is still under his enlightenment, and I don't think that he's going to overrule Grutter. Now, exactly how he underrules Grutter, perhaps, you know, he'll just say the Fifth Circuit was wrong. You need to look back at this under this more strict guidance, you know, because they are using race. Race does require strict scrutiny. You saw that the Fifth Circuit softened this approach too much, and they need to look at it again. Or they could do a more results-oriented approach and say, well, you know, what you did was wrong. You know, if we had said this in Grutter, we did not mean it. Yes, you can still have race as a compelling, or diversity as a compelling interest, but the way that the Fifth Circuit analyzed this and the way that we see the results, the outcomes in this case is it doesn't fly under Grutter. And so they just, you know, restrict Grutter. Exactly the level of how much they underruled Grutter, that's perhaps our biggest concern.
Thank you.
David, this question's for you. I'm a teacher at Riverside City College, and I'm interested in your background. I'm curious about what motivated you to pursue the legal profession. If you could quickly tell us.
That's a wonderful question. So, yeah, I wish we had the opportunity for each person to answer that, particularly since we have students in the room. But David, what motivated you to fight the hard fight?
To the degree that I went to, because I knew I was going to eventually end up going to college. I didn't get a scholarship coming out because my parents didn't fill out the FAFSA on time, and I didn't think that I should have to pay my own way, so I ended up going into the military. But nevertheless, it was, I don't know exactly what it was. My sister dropped out. My older sister dropped out. My older brother graduated, and then he just, sat there for a few years, delivering pizzas. My younger brother actually had the best thing because we got out of the house and he got to go to private school. But eventually I followed the law because I read Jonathan Kozol's book, The Savage Inequalities of Education, and saw that it was law, not policy, that helped really change matters, had the really big impact in Texas, and that's what really opened my eyes to how bad we had it at Edgewood. I knew that, when we went and played at Alamo Heights, they would call us wetbacks and throw rocks at our bus, but it was like, oh well, that's Alamo Heights, that's what you expect. But as far as that great opportunities they had compared to us, even though we were all held to the same standard, that's what motivated me, and now I've got my dream job.
So Jonathan will be really happy to hear that. Actually, can I just extend that really briefly, Bill and Robert? Because you guys are doing stuff at the edge. What brought you here?
Thank you. That's a long story.
Make it short.
I'll make it short. I think I went into law originally for not the best reasons. I just wanted to become rich and powerful and make a lot of money. My enlightenment came at the end of my first year in law school when I went through a deep soul-searching process, and I realized, okay, life has got to be about more than that, and that led me to feel a calling to become a professor and to use the platform to speak and write about issues of race, especially coming from a Chinese Mexican background. Those issues are always on the forefront of my mind, or oftentimes, and so that led me to do the PhD after law school, and here I am.
Bill.
Sure. I think anybody who does social justice lawyering and social justice research and work has both, personal and political motivation. I mean, for me, it wasn't lawyering per se. It was education reform that drove me. I grew up in a rural, working class, high poverty area in northern Michigan, and thought I had a gold-plated education until I went to college and realized that there's these things called AP courses, and my God, what is calculus? I've never heard of that. So woe is me, right? I thought that was unfair. Nothing compared to the experience I had when I started tutoring at a place called the Maxie Boys Training School. That is a huge euphemism for prison for boys in Michigan. And I saw those kids. I was 19, they were 18, 17, my age. Their book for the grace of God kind of thing, right? And what was the difference? They got screwed in their education. That was it. I mean, I got angry about that and wanted to do something. No. Did I do something immediately? No. Did I have a game plan? No. All I know is that the 1987 market crash said there were no jobs available when I graduated, so I took the LSAT. And the rest is history.
So Windy Road, but it was social justice and a passion for that got all of you there eventually.
I knew I was going to go back into education advocacy.
Thank you. Thank you for that nice question.
Yeah, I'm kind of a little stunned that the University of Texas actually doesn't consider sexual orientation and gender identity as part of requirements for, in the overall picture in order to admit their students. So I wonder what you think about that. And the other question that I have is in terms of the different instruments that are part of international law in terms of the right of education. How do you think those instruments impact national litigation perhaps in a way that could be positive for the cases that are coming in front of the courts?
Do you have both of those, David?
I heard the first part,
Yeah,
but not
LGBT.
about UT,
Yeah.
and not the second part. And I apologize because I told you all earlier that I was an air traffic controller for 7 years, and I got a lot of feedback in my right ear, so I actually have a little bit of loss of hearing, but no veterans benefits.
Yes. The second part was for the other person here.
For Bill Karski.
Could you repeat again, Patricia?
Yeah, well, I think I need a little bit of help. This is about the instruments that one could use.
Yeah, it was, it was in regards to the instruments, international instruments that are used in terms of rights to education, how actually they, if they're used,
Oh, good,
how
yeah.
do they impact international
Great question.
education?
Great question. I can't. Yeah.
David, you want to start with the LGBT issue?
Yeah, I mean, just real briefly, at UT, I don't know. I don't know the demographics of UT as far as, the LGBT population and exactly whether or not they're represented. I know that there are groups, on campus, that we've worked with on different policy issues. The Austin City Council recently was one of the first Texas cities to step forward, well, behind Houston and a couple of others, but there was where they stepped forward and they said, well, we're going to honor them for having benefits. I know that might be surprising to hear that that's a great thing, but it is in Texas. So, I don't know, what type of affirmative action efforts are, one, even necessary, assuming that there is an underrepresentation of the LGBT population on campus, or two, if they're necessary because there are certain barriers, affecting their access to the University of Texas. So, I apologize, but I'm really not knowledgeable on the issue. But it's certainly relevant in looking at a holistic review of an application, because someone's gender and sexual orientation, they don't check that at the door. And, it can definitely lend to a positive discussion, within the classrooms. Thank you.
So the second question, as I understood it, was to what extent are international conventions or norms regarding the rights to an education used, or how could they be used in the domestic context here in the U.S.? I like the question only because for the first time ever, I think we've seen how some international norms can be effective in the juvenile death penalty case. We really were successful in that case only because we were embarrassed compared to the rest of the world and the norms that they have established with regard to killing kids. So there are, of course, international norms and rights to an education that exist. One difficulty that we have is the U.S. is not a signatory to the UN Convention on the Rights of the Child, which would give a real hook that we could bring in to enforce the rights of kids. Having said that, though, I think this is a place that is undermined and underutilized in terms of the way we think about advocacy work. I know that I'm probably as myopic as everybody else and need to think hard about how, even though we're not signatories to those conventions, how we can use things like the right to an education that exists in some of these international treaties and conventions here domestically. And other constitutions for that matter. I mean, read South Africa's Constitution on Education. Whether it's implemented is a different issue, but it's beautiful in its text.
Thank you. Is that Laura?
Yeah, good morning. My name is Laura Gomez, and I have a comment, which it is a question. I don't know how much time there is to get to this, but I do want to throw it out there.
This is probably going to be the last question, Mark.
One of the things that we wanted to do in today's summit was to make sure that people were crossing disciplinary boundaries, and so we have actually we have people with 3 law degrees up on the dais, but also a historian, and then Mr. Koski has his degree in education as well. My question is, if we try to combine, if we would try to really cross those disciplines, where would we end up? And again, this may be something we talk about later in the day. But your work strikes me, Robert, as really important for laying out the work that history can do to say, these inequalities that we have today, they're not accidental. They were deliberate attempts, and it was not accidental that they would surpass generations. They were meant to perpetuate generational wealth for certain people and to perpetuate generational poverty for other people. So my question is, how can lawyers get outside their comfort zone, litigators and policymakers, to use some of that other research and some of that other insight from other fields? And in particular, what do we need to do in California so that we can recognize, for example, why isn't the legislature demanding apologies for racially restrictive covenants and the kinds of segregation that produced? Why aren't we fighting some of these battles in the legislature? I mean, I know that we are, but thinking about the legislative front, thinking about litigation, and really crossing into these different zones. I think there's been a lot of focus on law, and I just kind of want to bring it to those other disciplines as well.
So how would you guys like to approach this question?
I could say something very briefly. Back in 2004, when we did the last Texas school finance case, and one of our chief issues was equity, the equity gap between the property rich and property poor districts. There was about a $1,200–1,500 gap for no reason except the zip code that people lived in. And we had a historian come in and testify about the history of discrimination. The state jumps up and says, oh, it's not relevant. You don't have any equal protection claims in this case. And, it was a little stretch, and it was a little sexiness that we wanted to introduce into a school finance trial. But, it was also very relevant because it talked about the communities and how those communities continued. Then we had another professor come in, and she talks more specifically about Bexar County, much in the same way that Robert had talked here about what went on in California with the covenants and so forth. And, in Bexar County, we had 14 school districts just in one county. That's where San Antonio sits. And she talked about how these restrictive covenants had kept people in, and, the state also had objected to her testimony too. And they asked her, and the court said, no, I want to hear this. And at the end of her testimony, the state, which one lesson you learn as a lawyer is not to ask a question that you don't know the answer to. And they said, well, you're not saying that these covenants, that these racially restrictive covenants or anything of the like is still going on in today. And she's like, well, I'm not saying it, but I can say it. And they said, well, what do you mean? Another question they didn't know the answer to. And he said, she said, well, when you're driving around down the highway, just from, on my way up from I-35 from San Antonio to Austin, I see homes 250,000 and above, homes starting at 500,000. That's not opening access to people, to all people. And it just laid it at there. So, I think that there is definitely an opportunity. It's something that we've always done, both in our policy work, because, I'm not an educator. I can't tell you exactly what it needs, what a school needs to make it work. But I go out and get Professor Linda Darling-Hammond from Stanford. I go and get, other professors from around the country to come in and say what we need. So I think, definitely, even in the litigation context, there's a real collaboration, and it's necessary to try and prove these very difficult cases.
Can I just add 2 quick points?
Absolutely.
One is I'll say, tagging on to that last bit, working closely with social scientists and other folks who understand this is essential to modern litigation, as Professors Orfield and Gondra know, who have done work in this area in the past. But I will say, and this is a shout out to law students here, you're in a great university. I don't know whether you're allowed to take courses outside of the law school. Sorry, Professor Moran, but it's not a bad idea to get out there and experience some interdisciplinary work and realize the interplay between law and social science, law and other disciplines out there. I think this is where we need to go. We need to educate ourselves. Law is not a self-contained world. It exists in the social world out there.
Thank you for that comment, Bill, because we constantly make that same suggestion to our students in the Graduate School of Education, that this is your last best chance in your life to take advantage of some of the best minds in the country. Grab it while you're here. Robert, would you like to make a last
Sure,
comment?
I'll make a brief one. Thank you so much. To speak about my experience as a historian, I think that perhaps history can force a moral impetus upon change, if not an official legal one, by shocking people. Like, for example, like this issue of restrictive covenants and segregation was not just something that was in the 1940s. It was an issue that was not officially resolved in terms of just residential segregation until basically within my lifetime. I mean, so
And
there,
we know that's exactly 40 years.
more or less, más o menos. So there was legislation, state legislation in California passed to abolish race-based segregation and gender-based segregation, and there was a state ballot initiative in California which overturned that. Can you imagine how crazy that is? So the legislature said you can't discriminate based upon race in housing. And the people of California, by a majority vote, said yes, you can. Right? That's within my lifetime, basically. So I think the more that history can get out there, it's shocking, actually, and hopefully that can, again, provide a moral impetus for changing things in the present.
Thank you very much. I want to thank this panel for extraordinary presentations, really engaging, interesting, and at the very edge of where the law is in this. And also for having stayed within the framework of the time, even though we got started late. So that there was, in fact, an opportunity for people to ask some very, very good questions. We're going to take, I think, about a 10-minute break. And please, does that make sense, Carlos?
I got some announcements.
Oh, okay. We've got a couple, we have an announcement here, and then Carlos will tell us how much of a break we're going to have. Thank you very, very much.